again, for the benefit of those just joining us, the topic is Introduction to Law of Evidence and Classification of Evidence. And we have said that the major distinction between a lawyer and a layman is the ability to recognize the type of evidence that is legally admissible and how to produce it in court. That is to say that it is not every piece of evidence that is admissible in law. There are some that may be relevant to the fact or the issue that is being considered, while some may not be relevant, and of course may be relevant to other things. For example, if I ask a student who is presently in class before me that how did you get to class this morning, the student is likely to tell me a story starting from how he or she woke up this morning, and after he was up prepared, you can even say that I looked at the ceiling and the ceiling looked at me. I did not feel like going out today, and I just felt like I should just sleep on my bed. There's no need to go out. Recall, he's trying to answer the question, how did you get to class today? And he said, well, I just knew that there was no way I could meet this class. I have to come all the way. So I quickly had my bath, took a cup of tea because I was already running late, and then joined a public transport that brought me to the faculty. Now, all that is relevant to my question, or that is useful to my question, is the fact that I joined a public bus that brought me to the faculty. But you realize that the person has told us an epistle of how he or she woke up and did not feel like going out at all. All those stories cannot completely be ignored or be, we can't pretend as if they don't form part of the story. But of what use is that piece of evidence to the question? So meaning that in every action, maybe a crime or a breach of contract leading to a suit in court, there will always be stories or facts that are not relevant to the facts in issue. If it's not relevant and then you have produced that evidence, it cannot be admissible, meaning that it's not useful to the court. There's an alleged case of theft of a car, and you are presenting a document, you are presenting a survey plan of a house in proof of the theft of a car. The question is, how do they relate? But if that same individual is presenting the document for the said car, that piece of evidence, for all intents and purposes, is likely to be admissible in court. So, having been able to establish what is likely to be admissible or not, the word admissible there can simply refer to the process of the court accepting that piece of evidence. So, the next thing is, how do we produce it in court? That is the business that this the law of evidence focuses on. It's one of the businesses I have an example here. It says that in a case of breach of contract, Mr. A collected money from Mr. B and failed to produce or supply the subject of the contract. To a layman, a breach has occurred. Why? Because the other party could not deliver. But how does he satisfy the court? By adducing evidence to show that Mr. B has performed his own part in the agreement leading to the contract. That's how is the business of the law of evidence. So simply put, the law of evidence guides which facts should be presented to court, especially in a particular action with a particular fact in issue in focus. Like the example I just gave, the fact in issue is whether or not Mr. B, A, has collected or whether he has breached a contract. So fact in issue, as we will see, is the central point of a particular argument or anything that is being a subject of review at the particular time. So the law of evidence guides which facts should be presented to court. Now, it's good for us to look at the working definition of evidence. Permit me to say that evidence is not defined in the Evidence Act. And the word evidence can be used in two senses. One is the general sense, while the other is the technical sense. There are people in this class, probably within the hour that today started and now, they have used evidence twice to drive home a point. Say, maybe you were talking to your son and said, did you do the assignment I asked to do? He said, Mommy, I did it now. Okay, how can you prove that? What is the evidence that you did it? That usage comes or falls under the general use. The general meaning or sense is evidence will mean anything that gives reasons for believing something or make clear or prove something. That is in general sense. What is the evidence that it rained in your area this morning? Presentation of the video of your car with water on it. Of course, not the kind of water that may come on it when the car is being washed. Of course, the difference is there. Why one will have the rain, we have like the shower type of signs on the car. The car wash water will probably be flat because of the direction which the water is poured on it. So the presentation of a wet car or wet ground or a wet road will mean that yes, indeed it rained. Only just because to establish that it rained. So in several ways, the word evidence can be used, but most times, as it relates to general sense, it's just to establish a point. But that is not our focus in this class, even though it's part of what we're learning. The focus is on the technical meaning and definition. Technically, therefore, Evidence is considered the legally admissible facts into which the court will inquire. It is considered as the legally admissible fact into which the court of law will inquire. It can also mean the legal means of attempting to prove or disprove the fact before the court. When there are parties before the court, there are actions. One is for, one is is against. Recently, we filed a suit, and in the process of filing that suit, it was a case of contracts between two individuals, contract of service. Our client was given the terms of contracts, which is we refer to as terms and conditions. And when we were to file the action, we deliberately, for some reasons, being part of the game plan, we deliberately did not attach that document as part of the first document that we filed before court. The reasons I cannot disclose at this point. And when we filed, the opponent replied and submitted another terms and condition. And in that terms and condition, they have changed several things, making it different from what we have with us. What attempt were they making? The attempt was simply to see how they can disprove the claim that we have before court. But where their problem lies is that the document was not signed by our client, and we will wait for them to show us how they gave it to our clients, because we already have evidence of how they gave the one they presented to us. So they tell us how the two, why they are different. Just like when you send a mail to someone, no matter how smart you are, once the mail has been delivered, you are not likely to be able to change what you have sent. So when the issues as to how were they sent, the simple thing is for the court to examine the mail and examine the content of the mail. So the question will be whether it's different from what the claim exists or what we will later present. So the effort of both parties, one is to prove, our own is to prove that there is a breach, but they have brought in a document to disprove what we claim exists. So that is the technical description or meaning of evidence. Again, to further elucidate on or to provide more definition on the technical sense of evidence, evidence is the means by which facts in issue are established before a judicial authority. Fact in issue, I've explained what that means earlier on. Evidence is the means. That means, that procedure, the steps that is taken to establish the fact that is before the judicial authority. And then we will add that the kind of evidence we are talking about here can either be oral or oral testimony or documentary. It can even go from the two that we have mentioned to even include circumstantial evidence, to include hearsay evidence, as the case may be. So with that, I believe that we have the basic understanding of what evidence means. Please, if you have a question, do well to indicate so that you can ask. I mean, you can ask, then we can provide answer together. The second topic is the function of the law of evidence. Permit me to say that the primary function of the law of evidence is simply to distinguish between what is legally acceptable in the court of law and consequently becomes admissible in evidence, and other matters which are not acceptable or that are inadmissible, such as rumors, hearsay, and opinion. These are generally inadmissible in court, but it is the duty of the law of evidence to determine which is a rumor or hearsay or opinion that are not admissible. As they are admissible facts, admissible evidence, and those that are inadmissible. Like we said, like opinion. Opinion, for example, is not a state of fact. It's what an individual feels. And hearsay is what you were told, or probably what you heard in passing, which in most cases do not represent the truth of the matter that is being discussed. Because as I'm giving this lecture now, if I ask you to report all that I've said, the content of my submission and what is being given to the person who is receiving the new message will never be the same. Because in the course of such communication, there are possibilities that the message must have been muddled up, while some salt are added to it, some onions, or some things subtracted from it. So, in law of evidence, generally, rumors, hearsay, and opinion are not admissible. So, number one function is that law of evidence helps to distinguish between what is legally acceptable and the opposite. Number two function is the law of evidence separates facts which are needed to prove a case and facts which are not needed. And of course, that will relate to the fact in issue. It's different from the first function that we looked at, which talked about generality of what is admissible or not, while the second talks about generality of what is needed to establish a particular case or fact that is before the court. Number three function is that the law of evidence is a guide to the court on adjudication of judicial questions. The law of evidence is a guide to the court on adjudication of judicial questions. The truth of the matter is that while a court of law is saddled with the responsibility to adjudicate properly on a question that has been put before it, the court of law is duty bound to do that in line with the rules of court. that court is duty bound to follow the rule of the game. So that being said, the law guides the court on how to do that successfully. Then that takes us to the scope of the law of evidence. The law of evidence form part of the adjectival law, that is, laws that deals with procedure and practice in courts. There are laws that basically deals with substantive law that only prescribe what is, does not talk about the procedure as to how X can be achieved, but it will just list X. So the law of evidence is one of the laws that fall under our laws that deals with procedure, as contrasted with substantive law that concerns itself with determination of rights, duties, and liability. Of course, examples of those substantive law include law of torts, law of contract, and criminal law. So the law of evidence covers questions such as the particular court to which a litigant ought to apply. It is not all cases that can go to any court or a particular court. The rule of evidence determines or guides where a particular matter can be filed, or the court that a particular matter can be presented to. And then also it covers questions, law of evidence covers questions as to the form of the proceedings to be filed. What we mean by pleadings, we include, in a simple term, the kind of papers that we file, while some we call them statement of claim, some we call them petition, and so on and so forth. Law of evidence determine that. Then law of evidence also determine the mode of proof, admission or rejection of evidence. If you want to establish a particular fact, law of evidence will tell you or determines or covers these aspects. How do you prove it? How do you present a piece of evidence? How do you establish it? What are the things you need to do? All of that also form part of the subject that the law of evidence covers. The other one is the cogency of different forms of evidence. I said that earlier, that the court will determine, and how the court will also determine is by the rules or by the provision of the Evidence Act. Okay, that is also the business of the law that is in focus, which is law of evidence. And then it's good when we look at sources of Nigerian law, sources of Nigerian law of evidence. Number one is the Evidence Act itself. I will encourage that you get one. because as we proceed in this class, you may need to refer to some sections therein in order to aid participation or for you to have easy access to it when we are referring to such sections in the course of the class. Now, just a minute. Sorry, can you still see my slide? Hello? Yes, we can see it. All right. Okay. All right. So. Yes, sir, we can see your slide. Okay, good. We can see it. Okay, thank you very much. So the third is what we call other Nigerian legislation. There are different laws in this country that enter that deals with law of evidence too. For example, I know that the NDLA Act provides a requirement that before anything can be tagged a particular substance, it is required that such evidence, such material must be tested. So meaning that it is not anything that looks like chalk that is cocaine. Okay, it's not everything that looks like chalk which carry the resemblance of what's it called, cocaine, that is cocaine. So those laws play some critical roles as and also work as sources of the Nigerian law of evidence. And the third or fourth is the Fundamental Human Rights Act. All of that also serve as the sources of Nigerian law of evidence. So as we go deeper now, we will now begin to look at classification of judicial evidence. Classification of judicial evidence. Do we have any questions so far? Hello, class. If you have a question, please you can indicate and then we will give you the floor. Okay. So, judicial evidence can be vertically and horizontally classified. It is vertically classified as oral and documentary evidence or affidavit evidence, while horizontal classification will include primary or best evidence, secondary evidence, real or demonstrative evidence, character evidence, oral or direct evidence, circumstantial or indirect, and so on and so forth. But under the Act, judicial evidence appears to be divided into three main classes, which are the oral evidence, documentary evidence, and real evidence. But for the purpose of this class, we are going to look at 6 major classifications. You may not bother yourself about the horizontal classification, vertical, and all of that. But we just have the required knowledge about the 6 that we have identified that we are going to deal with in the course of this class. So these 6 will include: 1, direct evidence. 2, hearsay evidence. 3, circumstantial evidence. 4, oral evidence. 5, documentary evidence. And 6, real evidence. So we're going to take them one after the other, and then we do justice to them. So the first one we're looking at is direct evidence. What is direct evidence? Direct evidence refers to evidence emanating from the person who actually perceived, heard, saw, or witnessed the fact in issue. Class, what did I say fact in issue is? Can anybody tell us? So that we can be sure that you are not just walking on the street and greeting a car aroma and you are with us. Good morning. Hello? Or is that person greeting another person there, not us? Mojisola Edu, you are not with us in this class. So can anybody tell us what fact in issue is? Hello, class.
Hello, sir. Hello, sir.
Yes.
Hello, sir. We are hearing you, sir.
Okay. So what is fact in issue? The fact that is disputed between parties. Yes, that's a brilliant answer. Let's work with that definition as provided. So you understand then when we say that direct evidence refers to that evidence that is emanating from a person who actually perceived, heard, or saw or witnessed a fact in issue. And that is distinct from hearsay. How is it different from hearsay? It's different from hearsay because the direct evidence or the person giving the direct evidence witness firsthand. There are some of us human beings that when we have seen something firsthand, we are good at not able to report it the way it was seen. Or you can report it under reports. Some are good at adding salt and all the condiments to the extent that the substance may even be lost in the process. So when someone who witnesses an incident is giving his evidence, the court will hold the one that is giving directly in a better esteem than hearsay, because hearsay, the message must have become contaminated or distorted to the point that it's not able to explain the actual transaction of the incident. So direct evidence prove or disprove a fact directly. I'll repeat that again for emphasis. Direct evidence proves or disprove a fact directly. Now we have some examples here. Examples we have here is that the fact in issue, example A, the fact in issue is whether Sule stole Yusuf's purse. Bala's evidence that he had observed Sule putting his hand in Yusuf's pocket and taking out a purse may be adduced as direct evidence of Sule's having appropriated Yusuf's property. Okay? If the fact in issue is that there is a missing purse and Sule, I hope there's no Sule in this class, has been alleged to have done that act, Bala has come forward to say, I observe, even though he's being careful with his language. He didn't say I saw. But the fact that he was present there as at the time the alleged theft took place summarily put him on the platform to give direct evidence. So his evidence is direct. It would be different from if Bala told Sunday and Sunday is now saying that Bala told me. That automatically becomes hearsay evidence. And in passing, I've made effort to explain what hearsay evidence is and the reason why it's a piece of evidence that is not generally admissible. The possibility of distorting the message, the possibility of adding what does not belong to it is also there. Now, we have another example which says that the fact in issue is whether A and B were present when C signed his will. D gives evidence of having seen A and B together with C at a table on which there was a document which C was signing. Class, I want to put it to you, or I want to ask, so let me put it to you, that this evidence, let me find out something now from you. This evidence, can it actually prove that C signed the will? Please, I need answers, please. Okay, thank you very much for your contribution. Yes?
I agree with her that it could be any document, not the will.
Are you from the same village?
No, sir.
Why did you agree with her?
Because it's my own view, what she said is right.
Okay.
It could be any other document. It could be a receipt or something else other than it.
Okay, do we have a contrary submission?
No.
You have spoken for the 38 or the 39 of us. Thank you very much. Now, it is part of practice that when someone who has prepared a will, who is known as a testator, if a man, and if it's a woman, a testatrix, the lawyer has prepared the will for him or her. That testator, that's the person who is the owner of the will, by practice is expected to sign the will in the presence of two witnesses sitting or standing, but must be present at the same time. Do you understand my point? So, if it cannot be established where there is a dispute that it was not my father that signed this will, my father could not have signed this will, my father loves me so much, why is he giving me only the house in Ikoyi and he gave my younger brother the one in Banana Island and Ijebu Ode? There can be disputes. So the question is, as to satisfy the requirement of signing in the presence of two witnesses, with this evidence here suggest that he signed a document in the presence of two people? The answer is yes. But whether or not it is the will that was being signed is another ball game, as suggested by those two people who are from the same village that answer the question the same way. But the evidence is that these saw. So any evidence from someone who saw is a direct evidence. But as to what is being signed in this case is another thing altogether. But of course, it will be presumed that that was what he was signing, because at the same time, they are not in any way, apart from the lawyer who prepared it, no other person is actually expected to know what is there apart from the testator, because it's supposed to be a secret document or a dead document that only comes alive, which everybody can now see when the maker is no more. So direct evidence has the ability to stand on its own and does not require any inference or deduction. Now, we must caution here that the fact that an individual who was present in a place is giving an evidence does not also mean that he is giving the truth account of what transpired. I don't know if the class is with me on that. So you can't be present and will not give the true state of the account. But that is not our focus. I'm just saying it for the purpose of enlightening or to enlarge our discussion. So in summary, direct evidence supports the truth of an assertion positively without any additional evidence or the intervening inference. We move on to another type of judicial evidence, which is hearsay evidence. And I usually refer to this as then say evidence. Then say evidence. So we're talking about hearsay evidence. Now, a piece of evidence is hearsay if the piece of evidence is being given by a person who did not himself witness a fact in which he is giving evidence, but fact related or made available to him by another person. Okay, that is what hearsay is all about. At one point or the other, we may not be able to run away from this kind of evidence coming forth, because circumstances of life does not give every man the opportunity to be everywhere at the same time. The only entity, I use the word entity because it's difficult to describe God, is that it's only God who can be everywhere at every point in time. So, but as far as human and God cannot be called in to come and give evidence, it's too large for that. But when situations occur where evidence is needed, and the person who witnessed it is probably no more or not available, the evidence that the person he had told becomes what can be presented to court. But like we said earlier, that by rule of evidence, generally, hearsay evidence are not admissible in court. But the fact that they are inadmissible does not also make its availability completely a nullity, because even if the person did not witness it and he has said it in court, the person may actually be saying the truth, but it comes to the court as an additional material through which a lot of things can be deduced, especially if the evidence that is being given by the person giving the hearsay evidence is such that corroborates or that has the element of truth in it. Because some people can be telling a lie and they are saying it as if they are saying the truth. Most times it takes the Spirit of God for you to be able to know those that are lying, even when they are lying. So let's leave that aside. That's just an addition to the submission of this. Let's look at the example of hearsay. A. Mr. A is accused of the murder of B. Mr. C testified to the fact that he heard B shout out a few moments before he was shot. And he said, for heaven's sake, A, put down that gun. This is hearsay evidence intended to prove the truth of what Mr. B had stated, namely that Mr. A was about to shoot him. I don't know if you are with me on this. I'll repeat for purposes of emphasis. Mr. A is accused of the murder of Mr. B. Mr. C testifies to the fact that he heard B shout out a few moments before he was shot. For heaven's sake, Mr. A, put down that gun. And we are saying that this is hearsay evidence intended to prove the truth of what Mr. B has stated, namely that A was about to shoot him. But what kind of evidence can we classify these statements if the purpose of having the evidence is to show that it was stated or the person said it? Hello, class. What kind of evidence can we classify it if the purpose is to show that the person made the statement?
So I think it's a direct evidence. Since he heard, nobody told him.
So if the purpose is to prove that it was said, you are saying that it will be a direct evidence.
Yes, sir.
I don't agree. Is anybody willing to give the answer that we agree with my own?
Sir, good morning, sir.
Good morning, ma.
I see it as a yes because nobody was there. What if the second person didn't hear? What if he didn't hear anything or something like that? Because only if there is a camera that shows and it can't be tested, the man said that. It might just be a people.
Àfikún ọ̀rọ̀. Ó ga jù. Okay, then that's okay. Let's hear another view.
I think that it is hearsay, sir.
It's hearsay, so it cannot be any other type of evidence. If the purpose is to,
yes.
Okay.
Because he had started talking and it testifies to what he had.
Okay, so it's still hearsay. Even if the purpose is to prove that that statement was made. Where are the men in the class? Hello? Good morning. It can be circumstantial. Okay, let me ask. Can we say it's a direct evidence if the purpose is to establish that the word was spoken? Because the first speaker said it's direct, and I said I disagree. But I'm now asking, can it be a direct evidence? How?
Because the person was there, he heard it. The person heard what happened. I want to take the other person. So that's the reason that I forget that it's
All right. So, frankly speaking, I agree with the first answer. The first answer said is direct, and I agree. I was just trying to test the class. If the purpose is to establish that it was spoken, somebody had it. The one who had this is different from the one who didn't see and did not hear. Now, let's move forward. A piece of evidence may be hearsay on one hand and may be direct evidence on the other hand, depending on the use of which or such evidence. That explains the query that I've just put to you now. So that's why the person who answered first realized that the focus is whether or not that statement was made. But whether it was directly there or he saw is a different thing. But when you look at the definition that we advanced on this, that evidence, hearsay evidence, or direct evidence is the evidence emanating from the person who actually perceived, heard, saw, or witnessed the fact in issue. So seeing the fact in issue alone does not qualify it to be direct evidence. Class, are you with me, please?
Yes, sir. Yes, sir.
All right. So it is hearsay if a party gives the evidence to prove the truth of the content of a statement. Why will it be hearsay? Is that if the person was not there, like in this case, the Mr. C gave evidence that he had, but he was not there. But it is not hearsay if another witness merely seeks to establish the fact that the statement was made. And that was where I picked my question from, to ask whether it can amount to a direct evidence if the focus is to establish that the statement was made. Like the last person said, that he had it, not that he was told. Okay? Do we have any question before we talk about the next type of evidence, which is the circumstantial evidence? Which, okay, can you see me where you are?
No, sir. Yes, I want to see your slide, sir.
Okay, but you can hear me.
Yes, I can.
So if I say that tomorrow that fuel will become 100 naira, if the purpose is to show whether I made that statement, can it be direct evidence?
Come again, sir.
I said, now you cannot see me.
Yes, sir.
But you can hear me.
Yes, sir.
So I want to make a statement. It's not a prophecy, but even if it's taken to be a prophecy, if it comes to pass, all of us will enjoy it. So the statement I want to make is that by this time tomorrow, the cost of fuel will become 100 naira per liter. You laughed. Don't be like Sarah. So if you are asked that did I make the statement, what would be your answer?
You can just say, because I didn't see you, I just had.
Okay, that means you didn't get the definition of direct evidence. The definition of direct evidence will assist you to understand what we are saying. So the definition of direct evidence is that it is the evidence emanating from the person who actually perceived, heard, saw, or witnessed a fact in issue. So that's why I said that mere seeing alone is not what qualifies an individual to be given direct evidence. The fact that you heard me, even though you are not where I am now, okay, and the purpose at that time was to affirm or confirm that the statement was made, it becomes direct because you heard it. Do you understand now, ma? Yes. You said what?
Because it's virtual, but I can't see you. I'm just hearing you.
Yes, but the fact that you heard qualifies. If they now ask you, did I say that you heard? That's a direct evidence. But you didn't see me, and the fact that you did not see me does not reduce it from the hearsay. I mean, from direct evidence, because even if you didn't see me, but you can hear what I said. And the definition that we provided is to the effect that once you can hear, once you can perceive, once you can witness or you can see, it classifies that into direct. Okay. Do you understand now, ma'am? Okay. All right. So thank you. So now let's look at circumstantial evidence. Yes, please. Good morning. What did they do to your voice? Really? All right.
So the question is, what if the party giving the evidence actually assumed that they heard it was not that he actually said this? What if part of it who was giving the evidence?
Can you repeat that again?
So in the example we just treated,
Yes.
so the question is that C is the one giving evidence that he heard B saying, put down the gun.
Yes.
So my question is, what if in the actual sense, C was only assuming that he heard B making that statement? What if in the actual sense B did not make that statement, but C merely assumed that that was the voice of B? When there is no voice recognition machine in place, therefore determine that it was actually B's voice that he heard.
So as a matter of fact, the voice is not even longer available because there was no recording. But is it possible for C to assume?
It is possible. To me, it is possible, sir, because C might even be, the TV might be on in, maybe he's in the room and his TV is on in the sitting room, and a similar statement emanated from a show happening on the TV. So he might have thought, oh, that is B's voice that he heard. To me, because it happens. Sometimes you hear sound or exact statement from the TV and it's being said outside or something. I've experienced it before.
But what if indeed B was dead as at that time? As indeed B actually died within that space of time.
Okay.
Will it still create a confusion that that statement was made? Because, and that's circumstantial, because we are assuming now that what if the person can, somebody may not really assume that kind of a thing. In my own estimation, I may be wrong. The person may not really assume that kind of a thing, because that's the thing, that's the last thing you can be imagining or you thinking you are hearing, especially when things like that is not happening. So for somebody to have alleged that kind of a statement is an indication that, oh, somebody actually, something happened that led to it. But again, from the face of it, since it is now a fact that B is now dead, number one, and that B was killed by a gun, it is circumstantial enough for anybody listening to Mr. C's story that he had A shout. I mean, that he had B shout that A, please put down the gun. So all of these things, you said what?
I said I agree with you, sir.
Yeah, so
the fact that B actually has died at the time we are considering this fact.
Yeah, and it was not, he didn't die by reason of cuts from a machete. So the evidence on ground are kind of corroborative. What I mean by that is that, one, the evidence on ground tends to give credence to each other. If when they now examine B, they didn't see any evidence of gunshots, but when autopsy was carried out, they discovered that his system was poisoned, then you know that that statement cannot sell.
Yes.
But again, it may serve to some extent that After B must have shouted, for heaven's sake, A, please put down the gun. And A decided to put down the gun and pour the poison that he has made in the mouth of Mr. B. All of these are possibility, don't you think so?
Yes, I agree with you. It's possible.
Yeah, but the circumstances surrounding it will assist in unraveling the situation, especially the police officers around. I mean, listening to this class would have risen a lot along in terms of investigation. How, if it is also shown that when the B was discovered to have died, the key leading to the house was not found in the house, and it was seen that somebody locked the door from outside, or the door was locked but the window at the back was left open. Investigators will conclude that, oh, it was the two of them that were in the house. The door remained locked, not broken, but the window at the back is now open, suggesting that someone, the assailant, must have escaped through that means. So these are things that will come to play. But the thing about all of this is that the circumstances of each case will determine the outcome of the things there. Do we understand, class?
Yes, sir.
Okay. All right. Do we have any other question? Okay, we move on. The next topic is.
Sorry, sir.
Yes, please.
So I think you've dealt with this hearsay evidence by giving an example of a scenario that is not a hearsay evidence. So I would want you to also create a scenario that is actually a hearsay evidence, so that clear distinction can exist.
Okay.
What I mean is, the scenario you just gave is not an hearsay, as we all later agreed. So can you as well just give us a scenario that clearly distinguish between this one and a real hearsay evidence? Thank you, sir.
Okay, you're welcome. Now, I'll go back to the same example. Mr. A is accused of the murder of B. Mr. C testified to the fact that he heard B shout out a few moments before he was shot. For heaven's sake, A, put down that gun. Now, let's say that when this incident happened and it was reported to the police that Mr. B has died, Mr. C, who heard the shout, is not likely to keep quiet, isn't it? Because when incidents like that happens, everybody will begin to say what they know. People will begin to put theories together. Even those that are not intelligent officers or that are not, they don't have anything to do with crime investigation, will begin to put a lot of theories together. Even those who live in the house will begin to say things that may relate to the incident. One may say that I didn't even hear anything. No. It was a TV sound I was just hearing. But later on, I heard maybe the table was like somebody was pushing a table. He said, that's the only thing I know. Different people. But one thing that is clear is that Mr. C, who actually heard, would have also say what he had to people around. Let's say that Mr. C had told his younger brother, Mr. D, that when they see, in fact, I was just going about my normal business when I heard Mr. B shouting and say, hey, put down that gun. And he told his younger brother, who is Mr. D. And when investigation continued, Mr. A, who actually committed the offense, learned of what Mr. C is saying, which is something that directly implicates him. And Mr. A, before he was arrested, located Mr. C and killed Mr. C. And now, the case of the alleged murder of Mr. B is now in court. If Mr. D, the younger brother of Mr. C, who was told what B said before he was shot, now comes to court to say, my brother C, Mr. C, heard what they said, and he told me that in fact he heard that, for heaven's sake, hey, put down that gun. He said he told me. That evidence that Mr. D is giving is hearsay evidence. Do you understand?
Very well, sir. I understand.
Okay.
And,
Okay. So it will amount to hearsay because it was not D that had it, but he was reporting what he was told. Okay. So let's move on to circumstantial evidence. Circumstantial evidence is also known as indirect evidence.
Hello, sir. Carlos, sir. Stabile ló sọ̀rọ̀.
Hello? So, in circumstantial evidence is also known as indirect evidence. This is the evidence of some fact, not actually in issue, but relevant to fact from which a fact in issue can be inferred. Now, what do we mean by this? Is an evidence of some facts that are not actually in issue, but relevant to a fact from which a fact in issue can be inferred. Can anybody try to explain that to me from the class? Let me have an idea of the general understanding that you can have based on this statement that has just been made. That will serve as a foundation for us to understand what we want to talk about. Anybody? Hello, class.
We think I don't get the definition properly, sir. If you repeat, so you'll be able to understand.
Can you see my slide?
Yes, sir, we can see.
Okay. So
when you talk about it, it's easier for us to grasp.
Okay. So I said circumstantial evidence is the evidence of some facts not actually in issue, but relevant to a fact from which a fact in issue can be inferred. And I said, what do you understand by that? Is your understanding, understanding may not be the actual thing, but share with me what you understand.
May I go first?
Please go ahead, sir.
So my understanding here is an act done which may not directly relate to the fact being investigated or fact in issue, but which may complement or indirectly lead us, from which we can draw difference in the course of determining the fact in issue. And an example of that is a neighbor's house was burnt to the ground.
Okay.
And investigation revealed that it was burnt it was set ablaze using fuel.
Okay.
And lightning.
Okay.
And then it was established that one of their neighbors, the previous day at night, went to the nearby filling station to buy fuel in a jerry can, which people saw him taking into the house.
Okay.
So I believe that is a circumstantial evidence which may not directly show that that person was responsible for setting the neighbor's house ablaze, but can kickstart an investigation which may eventually lead to the cause of the incident. That is what Yoruba has called So that's my understanding of it, sir.
Okay, thank you very much for that contribution. It's a good one. And so a man now cannot buy fuel to come and use for his generator.
Well, you just have to make sure your neighbor's house is not burnt.
Then, so every time the Ajay cries now and something happens, is the Ajay that is responsible?
The Ajay can be called in for question, sir.
Okay. All right.
Sir,
thank
I
you.
have another instance, sir.
Please go ahead.
Okay, so like in the last example.
Yes, ma'am.
Assuming the scenario where somebody is telling the court that Mr. Heke will kill Mr. B. He had observed him like a week before, getting angry and furious that he has been duped and that this business is no longer making sense, is going down, but he must make sure that those people behind this predicament also goes down. He didn't mention name. He was just talking about his business or his investment, that some people standing, everybody that was involved in this scam, he made sure to go down one way or the other. He was just angry.
Yeah.
Saying, oh, I've lost so many millions. What's this? What's that? I think if that person now comes to the court to say, a week or 2 weeks before, I heard this man saying so. He didn't mention it, but he was angry. He had lost money and said everybody connected will go down. Or he would deal with it. So, and that is circumstantial evidence, even though B's name was not mentioned, and the person giving the evidence does not know whether B is involved in A's loss of investment or being scammed.
Okay. Thank you for that. Also, this is also another beautiful example. Okay. But one thing we need to note about circumstantial is that there is no certainty there. So that makes your example to be good. If there is certainty of the fact that it was that man was one of those responsible, then we'll not be talking about circumstantial, we'll be talking about direct. Do you understand? Now, why I want you to understand that statement is that This circumstantial evidence is not the evidence that is in issue, but it is relevant to a fact from which a fact in issue can be inferred. Let me give you my own example to add to the two that have been provided. There is a report of housebreaking, and they've reported to the police, and in the usual manner, the police move swiftly to the site of the crime, that is the locus inco. And when they got there, they began their investigation, and they saw a wallet which does not belong to anybody in the house. And when they opened the wallet, they saw ID cards, they saw ATM cards, they saw some money, saw a lot of things that can identify who the owner is. Now, the discovery of that wallet is not a fact in issue, right? But the fact that the person who came to that place, who is not one of the members of the house, could have done the act, because from the fact, the information available on those cards, that person is not known to anybody in the house. The theft that has happened can be inferred from the presence of a strange fellow who mistakenly forgot, or his means of ID, everything fell off when he was carrying out the act. Do you understand my example? What? You do? Okay. So, the wallet is not the fact in issue, but it's an indication that the strange fellow who came to that place did the act. The discovery of that wallet is a circumstantial evidence. As a matter of fact, that was a live case that I gave you, that I witnessed in court some maybe some 19 years ago, when I used to go to court to observe proceedings and all of that. The robbery took place, and one of the robbers that came to do that act, his wallet fell off while they were doing that, while they were robbing. He didn't know. So it was when the police came that thing was discovered, and it was traced by the information provided there. And that was how he was arrested and brought to court. There can be several examples that can be given in this light. So, circumstantial evidence is relied upon by the court in cases where there is no direct evidence, and the burden of proof of a case lies on the person who alleges. And that's why I said, in our criminal jurisprudence, it is the state who has alleged that this individual has committed a theft. Therefore, the state has a duty to prove the guilt of that individual. So therefore, I repeat that the burden of proof of a case lies on the person who alleges. In discharging this burden, the best form of evidence in proof of the fact in issue is direct evidence. But where direct evidence is not available, the court will not have any choice than to rely on circumstantial evidence. Even though we have said that hearsay evidence is not admissible, we did say that the availability of hearsay evidence may serve as a corroborative proof, which the court can also rely on. But that will amount to an exception to the general rule that hearsay evidence is not admissible. And of course, hearsay evidence can also be a means to achieving justice. Now, let's look at the example that has been put before us in the court. Bola.
Excuse me, sir.
Yes, ma'am.
Please, I want to understand this circumstantial evidence very well, sir. I want to believe that any circumstantial evidence should be able to be linked to the fact in issue. Like the first example the man made, that a man was saw coming in with a fuel before the house got burnt. You know, the fuel can be linked to the fact that it can make the house go ablaze. What if the man was actually coming in with a keg of water a night before? How would we relate? I want to understand that the evidence must be able to be linked to the fact in issue.
No, it must not be directly linked, but it must be as a situation where the fact in issue, that they can provide a link to the fact in issue. Now, if indeed the man didn't come in with fuel, it was actually water that he brought. Now, if that is a case that is an issue, the investigators will want to know, is it that there is no water in the house, the water is not running in the house, that the man had to go and use 4 liters to carry fuel, to buy water? Number 2, if there is no water, if there is water in the house, will the man still bring out or bring in water in that 4-liter keg? Is a possibility, because what if it's the water that is bringing from Orioke, which is not ordinary water compared to what is running in the tap? These are questions that the police will ask. Then again, was there any issue between the house owner and the man that is suspected? Those are the questions. But what we are saying is that we may not have a direct link. It can even be an accident that the man kept the fuel, if he actually bought the fuel, kept it close to where there is fire. And then the question therefore will now be, where did the fire start from? Where the fire started from and where the man kept the fuel, is it the same place or very close? If the fuel was kept in the security house within the compound and the fire started from the boys' quarter, can we say it's the man who caused it, or it was the same fuel that was used? And then when there is fire incident, the certain part of the place will burn normally to the extent of how inflammable the things that are being consumed by the fire is. And then when the fire gets to where there is an inflammable object like the fuel, the intensity of the fire is likely to go higher than the usual wood that is burning. Wood of chair, wood of cabinet, wood of rubber. All of those things will come into play during examination, because when something is happening, people are usually around observing what is happening, even though they are trying to survey the situation. So when I said direct evidence brings certainty, circumstantial evidence does not bring certainty, but through the evidence, certainty can be achieved if proper investigation is further done. I don't know, was I able to answer your question?
Okay. Yes, thank you, sir.
All right. So let's look at the example together.
Sir.
Yes, please.
I want to. Hello, sir.
Yes, please.
I want to ask question.
Please go ahead.
This person that is going on his way, he now saw a purse on the ground. But the purse was attracted. He now picked the purse. He opened it to see international passport and some dollar inside the purse. As a goodie, he now tried to check inside the purse. He saw the phone number of that person also. He now picked and tried to call the phone number. So by the time they will pick, the person that will pick the call just answer with harsh voice. But he tried to calm down and said that he saw the purse on his way, and he said that to try and call the number that he saw on the inside the purse. So now the person now replied that he should wait within 45 minutes that he will come back. But the person, by the time he will come back, they trace the man. They ask where is the man is, and the man has gone back to his office. They now went to his office and go and arrest. They say you are under arrest, without knowing that it's police that picked the call. So when he said, what did he do? He said, when you get to the police station, they are going to explain what to do. When they get there, they told him that the person that holds this purse had just got shot yesterday evening. And they didn't see anybody that shot the man. That means he's the one that shot it. Does this stand as a circumstantial evidence?
It can be circumstantial, but from the story you've told, there are a lot of ways to it. Number one, having the purse, and it can be in position of the purse, which he actually saw on the ground. There can be a connection between him and the people who killed the man. But it will be difficult for the court to convict him if he can establish the fact that he really doesn't know anything about it. Because, number one, he may not even know the person that has been killed. There are ways to know whether they know each other. The best they can do is to search his phone. They can search his phone. If his contact is there, then they know each other. Or they search his messages, his WhatsApp, to see any message concerning the man. Or they went to the social media platform, there's no connection. It may be a difficult thing to convict the man, but that doesn't mean that the man may not be arrested, because he's deemed to have been suspected of a crime. Suspecting someone does not mean committing the crime. Do you understand? So it's circumstantial, but not to the point of making him look as if he's the one that committed the offense. Okay?
In essence.
Yes.
Yeah, in essence, can we just say that it is suggesting that something is true, but it doesn't directly prove
it? It may not even be true. It's not so. Okay. It may not be true, but anything that can lead to to resolving the fact in issue will amount to circumstantial evidence. It's not, as far as it's not direct. Okay. All right, man. So look at the example we have. Bola is accused of Tayo's murder by stabbing. Olu testified that he saw a pen knife stained with blood in Bola's possession outside Tayo's door, while he had Tayo moaning and groaning in pain inside his room. Olu's evidence is direct as touching the possession of a blood-stained pen knife by Bola. Whether Bola stabbed Tayo with a pen knife is a fact in issue. To this end, the evidence is circumstantial. Circumstantial evidence is proof of fact by inference from fact proof. So, looking at this example, there's a clear distinction as to what was seen and what is in issue. So, if Olu's evidence is that he saw a blood-stained pen knife with Bola, that is direct. But whether it was Bola that actually killed, of course, we have seen situations where a murder was committed and then they handed over the gun that was shot. Even in films, we have seen that. They make it look as if it's the other person that was that did it. So it now requires extra effort to prove. But that evidence is purely circumstantial because it's not direct. If Olu has seen Bola stabbing, it's a different thing, which is direct. Then the issue of circumstantial may not even come in. It may just come in as a way of adding to what is on ground. Okay? So that's for that. Let's move on. There is an example here, and it will come under the standard of proof of circumstantial evidence. And these are conditions to the application of circumstantial evidence. Okay? Number one, for it to qualify as a circumstantial evidence, it must be credible. Credibility is by mere examination or by mere examining what has been told. Okay? And okay, like the example we gave of a man who came to rob and unfortunately his wallet fell off. The discovery of the wallet and the fact that the man does not have anything to do with that family, is it credible? That is the question. Then there should be coexistence of circumstances connecting the fact to the conclusion. Still using that example, a strange fellow entered the house and then theft is reported. It's just like the Ajekela Nomokule ni kind of suggestion from the Yoruba proverb. There must be connection. And that is key as a condition that the court gave in the case of Achibong and State. Number three condition is that there must be sufficient and cogent proof pointing to the irresistible conclusion that the accused person and no one else committed the offense. In the example we gave about Bola, that circumstantial evidence is not is resistible, in that it's very possible that the person who killed Tayo handed the knife to Bola, and Bola was in shock, confused, didn't know what to do. He was just standing with the gun, with the blood-stained knife, when Olu saw Bola. I'm trying to make you understand that there are situations that when some things happen, the people who with some maybe somebody who witnessed it direct will become dumbfounded now that you use, or you become so confused and possibly just lose his senses as to what next to do. Just be standing, open his mouth like this, and be looking. That's a possibility. So, but for circumstantial evidence to apply, there must be that cogent proof pointing to the irresistible conclusion that the accused person, like the case of the purse dropping at the scene of crime, that person does not have anything to do with the house. How then did this purse get to that place? Is he able to establish how did he get there, and why is it that night that the incident happened that thing was discovered, and there is nothing connecting that fellow and any member of the family with that individual? So this condition is very important. Then fact forming the circumstantial evidence must be incompatible with the innocence of the accused person and incapable of explanation upon any reasonable hypothesis than that of his guilt. That's directly explain the case of robbery that I gave, example I gave. The thing is that the man was in that house. If there's nothing to prove, how to prove that, as to establish how his wallet got to that place, his guilt, the reasonability is that he's the one that did it. Because if you are in your house, wallet does not have leg and it cannot walk to that place. So this condition must be applicable in any case where circumstantial evidence is to be deployed. Then we move to the next example of judicial evidence, which is the oral testimony of a witness. Oral testimony, which is oral evidence. Oral testimony or evidence is a testimony of a witness, usually on oath or affirmation, given by his word of mouth in the witness box. In other words, it consists of information obtained from the spoken statement of witnesses, and oral evidence reflects that indeed it is the most common form of evidence. So, oral evidence is an important class of evidence. Section 125 unambiguously states that all facts except the content of document may be proved by oral evidence. So usually this is the simplest, and it represents another type of evidence. Oral evidence includes signs made by a dumb witness as provided for in section 176 sub 2 of the Evidence Act. Okay, because that is the way that a dumb and deaf and dumb person communicates. So example of oral evidence include the declaration in court on oath in answer to question put to him by a lawyer, and if he answer whether in writing, because these days now with the post to affidavit, we file it, the content of it is seen as the words of the person who made the affidavit. Other one is documentary evidence. Documentary evidence. What then therefore is documentary evidence? This is evidence derived by court from the information derived from the content of some document that is produced before it. Examples include the facts in issue in X case is Y's indebtedness to X. A computer printout on which evidence of the debt is recorded is produced for inspection by the court. Or in proving ownership in being in possession case, production for inspection of the purchase receipt of the accused in his defense is essential. So maybe a receipt evidencing a purchase of a particular object will stand as documentary evidence. Or when you are in a simple matter of landlord and tenant, and in the course of the proceedings you presented the tenancy agreement. Apart from tenancy agreement, you also presented the receipt that was issued to the tenant. Is also an example of documentary evidence, provided that the court can infer or derive information from it. And the last class of evidence that we're going to look at today is the real evidence. What then is real evidence? It said that real evidence is also known as objective or demonstrative evidence, is derived by the court from inspection of physical objects other than documents, which could be a place, person, animal, or thing. So real evidence is the physical things such as a machete, a gun, a charter, whether movable or immovable, that may be brought to court for inspection, or that the court may move to inspect in the case of immovable property. So all of that is what amount to real evidence. And we have an example here, maybe in an action relating to injury caused by a fierce and mischievous dog. If the animal is produced in court for examination, if the court can see that this dog indeed has the tendency to carry out that act, the dog become real evidence. If they bring the dog and the dog is intimidating everybody, making attempt to jump at people in the court, then the judge sef will really be careful, will probably ask them to move the dog out. But if they bring the dog and the dog is running away from people, number one is suggestive of the fact that this one does not have capacity to injure, or does not have capacity to carry out such attack that has been alleged. Just like when you go to a place where there is dog and you enter the place and the dog is running back, is barking and running back, barking and using back to go back as you are approaching, is going back. You know that one can probably not do anything. But There are some places you get to, as soon as you approach the gate, the dog is jumping at the gate, jumping at you, making effort to, then physically or mere seeing it, one can know that if care is not taken, it can even cause more damage. So in that, the court will classify the dog as a real evidence. So evidence of parentage may be derived from bringing of a child to the court so that resemblance to his alleged father or mother may be observed. Now some of us, when they put us side by side by our father or mother, you say the carbon copy of the father. So if the man is still denying that I'm not his father, and some things that is difficult to deny. So, conclusion, the term real evidence covers not only material objects and the general appearance of persons, but also the demeanor of witness or witnesses and the view of scene of crime in visit to the locus in co. Whatever the court sees, whatever the investigator sees as, as to show the existence of what is being said will fall under the real evidence. So with this, we've come to the end of the topic of the first lecture, which covers the introduction down to the classes of judicial evidence. If we have any question, please feel free at this time to ask before we close the class. Thank you.
I have a question, sir.
Yes, please go ahead.
Thank you very much, sir, for this lecture.
You're welcome, sir.
I have actually learned a lot, and I'm sure my colleagues, my fellow students have learned a lot as well. However, I want to be clear on something you said earlier
Okay.
when you were talking about ESA evidence.
Okay.
You said ESA evidence is not admissible except when it corroborates circumstantial evidence. So I want to know, is it only circumstantial evidence that ESA evidence can corroborate, or can it also corroborate direct evidence? That's my first question. The second question is, I can see you dealt with the topic judicial evidence completely, and there was no mention of dying declaration. So I want to know, has that been removed as evidence, or is it still admissible?
It's oral. That's oral evidence too. It comes under oral. Yeah, it's still a form of evidence. Okay. Yes. So the first one that you asked, I'm trying to remember now.
It's about ESA. I said when you dealt with ESA.
Okay, whether it's only circumstantial evidence that it corroborates.
It can corroborate, yes.
Okay. I think, to my mind, I think it can corroborate any type of evidence as far as needed facts are needed. Okay.
Is it then safe to conclude that ESA evidence are not admissible except when it is used as corroboration?
If we use the word corroboration, then we will have narrowed it down to only corroborative function. Yes. ESA evidence can also still function in different capacity as occasion may demand. So we will not limit it to corroborative proof. I just said that as one that is likely to
corroboration.
Yes, to come into play. Okay, but like
standing alone,
yes,
the evidence cannot be admissible.
Yes, because of the fact that it's very possible that the person who is reporting is not reporting what actually happened, or is not reporting accurately, because in the course of movement of the evidence, a lot of salt and sugar can be added.
It has not soft.
Ma?
It has not soft.
So
You have
you
to bring it and let me see, maybe it's soft. It has to soft.
Mama dey talk about beans wey she dey cook o.
Wow.
The beans never soft.
I thought the person was talking to us. Okay. All right. So
Go to mute herself.
so with that, then we bring the class to a close, and we meet next time by the grace of God. So please do enjoy the rest of your day, and God bless you.
Thank you, sir.
Thank you, sir.
Right.
Thank you, sir.
Yeah.
Thank you, sir.
Thank you, sir.
Thank you. You're welcome.
Thank you.
You're welcome. Yeah. Thanks.